Welcome to the Data Protection Café from the heart of Munich. Today's topic, internal company lists such as duty roster, sick list, and the like. What data protection aspects should I consider as an employer? Learn more in today's video. In the realm of data protection law as stipulated by the General Data Protection Regulation, GDPR, there exist several fundamental principles, one of which is that data may solely be utilized for the designated purpose and can only be processed to the extent that is necessary to accomplish said purpose. The relevant regulations are also displayed here once more. Let's have a look at what this means in practice for managing internal company lists, such as duty rosters, a vacation list, and a birthday list. When commencing the duty roster, it is important to note that duty rosters can typically be made accessible to individuals who are in any manner impacted by them. Only employees affected by the duty roster are allowed to view it and have access to the relevant information. In practice, the issue has repeatedly arisen, can I actually still post my duty roster? Due to the fact that employees from other departments may potentially have visibility into the structure of the duty roster arrangement. According to the report linked below, the Bavarian State Office for Data Protection Supervision affirms that the act of posting duty rosters remains permissible under the provisions of data protection law. It is stated that this is essentially an incidental matter and not particularly problematic in relation to the law concerning data protection and privacy. What about lists of birthdays? Additionally, it is argued that lists of birthdays may potentially be posted on the platform by users. It is crucial for the establishment of a productive work atmosphere and thus for the successful execution of the employment relationship that employees have knowledge of the specific date of their birthday. But the year of birth may not be published without consent. They can then secretly reveal internally how old they really are. And then there are the corresponding lists where absences are recorded. Sick lists, of course, necessary for team deployment planning. Similarly, the other co-workers may not necessarily require knowledge of the reasons behind their illness. So it is sufficient to simply note in these lists that a person is not present, and the specific reasons should not be publicly listed for everyone to see. I can do many things, but it is easiest for everyone if I simply sit there. And now moving on to the conclusion. The practice of keeping lists is generally permissible to the extent required and mandated by the provisions of data protection law. When it comes to the duty roster list, caution must be exercised to ensure that only those employees who truly require this information can access it, with the Bavarian Supervisory Authority indicating that displaying it in the workplace is still allowed. The list of sick individuals should only include information that is visible to everyone indicating their absence, but it should not provide specific details about the reasons for their absence. And lists of birthdays can be maintained, though without specifying the year of birth explicitly or precisely, only if the person's consent is provided. What else has occurred in the field of data protection? The Federal Administrative Court has ruled that the Federal Office for Refugees and Migration may only evaluate mobile phones if there is a specific reason. Details in the link in the description. Thank you for watching.